it's a smaller group. Well, it's 12. Are you all ready? Or do you want to wait? Are you good? Okay. All right. Hi, welcome. So I am Beth Kramer. I'm the Kramer of Guzman, Rose, Culvert, and Kramer. I know almost all the faces in here because this is my 19th year practicing here in Asheville. So I was asked to come and just do a little update as what you can see on restrictive covenants and the impact of the C Investments 2, the Auger et al. Claim. That was a Supreme Court action that came in. So since we're a small group, I do have just like a informational, what it is, what happened, what's the Marketable Title Act kind of agenda. We're going to end with other questions you guys might have about restrictions. I'm going to address a question I get asked all the time about restrictions to lead into that. And then we can just have a nice little round table conversation if we have time and if you want to, okay? I tend to also speak fast. So if it's too fast, anybody's welcome to say, hey, Beth, slow down, okay? It's just my brain. So the premise of all this is a 50-plus-year-old statute that we all call the Marketable Title Act. The Marketable Title Act says essentially that if someone has a clean chain of title for 30 years, they have marketable title, free of defects, free of, we always talk about this, prior heirs, any kind of claims, any interests. And so this is just the actual parts of the statute that you can see that are one that establishes how we, as a title attorney, we search title for 30 years. And that's how we get what in the contract, right? Marketable and insurable title for all of our clients, for buyers. And then the second part just tells you it precedes all kind of estates, interests, and all those claims. Let's say those are 40 years or 45 years or 30 years out. So this is a subject matter that has been the rule of law, like I said, for over 50 years now, that we as attorneys in the state have all used, and everybody's been protected, right? In terms of knowing you have marketable title to property. So then to that statute, we have certain exemptions. And there's 13 different exemptions. For example, like easements, right? We don't want our right-of-way to be extinguished because it's been 40 years that it's been established. So covenants, restrictions, deeds of trust that aren't otherwise like canceled or void at law. So there's 13 different exceptions. The 13th exemption is the one we're going to talk about today. And specifically, you see that quoted language. That was for covenants applicable to a general or uniform scheme of development, which restricts the property to residential use only, provided the covenants are otherwise enforceable. The otherwise enforceable just means they haven't expired. Sometimes they expire on a date or based on a condition, right? So this is the one that says that restrictions are supposed to continue and be saved by the Marketable Title Act, exemptions to that. So then comes this 2018, I think, lawsuit that was started by C Investments 2, LLC. At issue here, this was C Investments bought 7 lots in a very historical old Charlotte subdivision and wanted to build townhomes on them. This was single family use, old, big, grand estate properties. So he brought a lawsuit, or C2 Investments as an LLC, brought a lawsuit in 2018 against all the other lot owners to declare and get the court to declare that the restrictions were unenforceable under the Marketable Title Act. The basis of that was he was trying to say that the properties were only enforceable as to residential use, and that the rest of the restrictions, i.e. he couldn't subdivide, couldn't build a townhome, were not enforceable. So this is the first challenge to the Marketable Title Act that we saw and have seen in 50 years. The lower court held that his claim was valid, that the restrictions were unenforceable as to the rest, almost the entire declaration of restrictions. And the only one he was subject to was residential use. On appeal, remember that exemption said uniform and general scheme of development, right? For residential use only. That's the exemption in the Marketable Title Act. So on appeal, those owners said, hey, whoa, whoa, whoa. What about the rest of the restrictions? Because those are our uniform scheme of development that makes this a residential use development. Court said, no. It's too broad of an interpretation of the statute. And so the Court of Appeals said that the exemption to the Marketable Title Act was very clearly limited to residential use only. So it was a sweeping decision. If you remember, this came down in, I think, 2020 or 21. And then everybody was like, oh my God, no restrictions apply to property. And then it became like the Wild West. People were like, I'm going to do everything, build townhomes and apartments in my subdivision, you know? And so then finally the Supreme Court took the case. This is the North Carolina Supreme Court. And they held the case in 2022. This was heard by the Supreme Court. And they held that the Court of Appeals was correct in terms of the interpretation of the Marketable Title Act, that 13th exemption only applies to residential use only. That a plain reading of it would require that all the other restrictions are not applicable if they are outside of the 30-year period of time in title, except only if it pertains to residential use. So this was a windfall for developers, looked at as a windfall for developers all across the state, because this then meant what was previously a single family community now is only subject to residential use restrictions, right? Think of like all the old subdivisions we have around here that have restrictions that date back. I mean, 30 years is 1990. Okay.
Crazy, you know?
Right? So what was interesting in that Supreme Court decision is the Chief Justice actually dissented. He was the dissenting opinion. His opinion was that the language was to be interpreted broadly to include all restrictions, that was an overreach by the court, and the majority opinion was unjustified and unright. So lots of people say, does this open the door for this lawsuit, or one that's very similar, to still come back into the court system? So that lots of discussion on the bar level that is going to lead to future litigation that might make this all change a little bit. So after this was rendered in 2022, the legislature actually took an action. So from early 2022 to late 22, we didn't have any legislative response. Every attorney was petitioning, please do something to the House. So they responded, because what this did, if you remember, condominiums, right? Planned communities, townhome developments. This means all those restrictions don't apply. Do you have to pay HOA dues? Do you have use of your condo association amenities? So that they had to do something here, because if all restrictions that are older than 30 years don't apply, what happens to condominiums, townhomes, et cetera? So the response by the state House was they added a 14th exemption to the Marketable Title Act to make sure that if you're a condominium created under the Condo Act, if you're a cohabitation, which we don't have, those are the timeshares, we don't do those, or a planned community under the Planned Community Act, as long as you were created pursuant to that act prior to 99, and you have an active association that you didn't just put into place hurriedly in 2022 to respond to this, one that already existed, then your restrictions entirely, the entire covenants and restrictions for that community are not extinguished by the Marketable Title Act. So this was the state's response to say, no, we at least need to protect that organizations and communities that were established pursuant to the Condo Act or the Planned Community Act, because those are statutory structures for subdivisions and condominiums. What this does leave open is some older restrictions may still be void or unenforceable because not every subdivision was created under the Planned Community Act. That specific act is required if you have 20 or more lots. So we have lots of subdivisions that are under that, where we don't always make them pursuant to the act. And older subdivisions might not have been brought into the act, because I think that act is from 1990s era. So subdivisions made in the 60s, 70s, 80s weren't always revised to be subject to the Planned Community Act. So a very local example is 550 Lakeshore Drive is a single family house in Lakeview Park. It backs up to about 6 acres of property that only has a strip of land that connects to Lakeshore, not wide enough for a subdivision. Lakeview Park's original restrictions were deed restrictions, not a declaration of restrictions, deed restrictions done on each property in the 40s and 50s. And they prevented subdivision, right? Certain house restrictions, size restrictions. The subdivision of property was the big one and is the big one here. So developer bought the 5 acres, person at 550 died, they acquired that house. Now they have a house to demo to have access to re-subdivide all that property. Lakeview Park Commission is freaking out. So the Lakeview Park Association is very active and responsive. But the argument of the developer, based on C Investments 2V Auger, is I'm going to use it for residential purposes. Your subdivision restriction on this house is void because of this lawsuit by the Markville Title Act. Because Lakeview Park is not a planned community under the Planned Community Act, it is a deed restricted, old original, development. So the city, fortunately, this is in the city, is requiring a lot of petitions and community meetings. And this is probably going to turn into a lawsuit between the association and the developer. It's not there yet, but that's one that's sort of hot on the table. It's going to make, I think, 20 single family lots out of the property. I think another interesting example is Biltmore Forest. Those are all original deed restrictions. So nothing obviously is happening there that I know as far as a current event, but those are the types of communities I think where, they really have to be conscientious about the impact of this change to the Markville Title Act in terms of protection of their communities. So we've actually been trying to inform clients of this when they're rebuying or buying in, older communities. And it's an important part of the Markville Title Act. If you remember, as I said, 30-year chain of title. So what was interesting in C Investments too was his title for those 7 lots never one time referenced any of those restrictions. If one of those deeds would have had it, they wouldn't have had the claim that it was free of the Markville Title Act, because it would have been reincorporated into that chain of title, those original developments. Biltmore Forest, a lot of times we reiterate those restrictions because those are from the 20s. Those are old. Sometimes we can't find them anymore. They're so old. Lakeview Park is now telling all their owners to do that in the same way, like keep reiterating them in deeds. And that's what we're trying to educate, like developers or associations, to just start maybe having that as a requirement in their instructions for us for closing. It's like, hey, could you please go ahead and include our restrictions as a reference? I think that's just the safe way that communities can help keep things in title. I will say that once things are in title, It is not required for us to include them in a legal description because they attach to the title. What we're talking about here, though, is survival of the 30-year marketability of title. So to make sure it stays surviving, even if it's outside of 30 years. Example that we wouldn't have to include it is it easements. Remember, easements are already an exemption that survive marketable title. So this is just that we don't include everything that we find in a title exam in a legal description, but this is where you can keep restrictions actually bound and surviving that 30-year time frame. Yeah.
If for the neighborhood, the restrictions were not renewed, but they are still being attached, are they voided or are they still valid?
I think it will depend on the language of those restrictions. Because a lot of them say these will be valid for 10 years and then they'll auto renew for periods of 10 years unless there's a majority vote by the owners to change them or terminate them. Some older restrictions say these will survive for 10 years period and then they're void. Example is I live on a little road in Lakeview area that has 6 lots on it, and we were privately restricted by a developer, and I might have been the only person that knew our restrictions expired in 20 years by date in the restrictions. Now we're subject to the city, so everybody was like, I'm fine to not have one more set of restrictions. But that was an example of certain like restrictions that had an end date specifically. So when those end, you can't revive them by putting them in a legal description. Does that make sense? You're only if the restrictions remain valid and you want them to survive the marketable title period. Do you keep including this? Not my subdivision, call it, would have been a perfect example of it would have been voided by the Marketable Title Act because it was done in this early 80s. And it's not a planned community. It's only 6 lots. It was just this little set of restrictions that applied to all of us. So even if it wouldn't have had an actual expiration date, it would have been voided by this change to the Marketable Title Act. So the impact of this, as you can see, I already said, it's creating a lot of property associations, really a lot of panic, a lot of concern, and it's also causing a lot of interest in developers and industry leaders because what was otherwise potentially not usable property is now potentially usable in a different way. So thinking of C investments to the Auger, right? Those 7 lots were supposed to be single family houses. Since then, those are townhomes. Those are duplexes. There's even an apartment building on one of them because that's residential use. And that's all they're subject to anymore. So it is just what can change the dynamic of the community, if you think about that. So what I say here is it takes more effort than ever to know the answer is we have to know as attorneys if your clients or you are trying to subdivide a lot. We've always wanted to know that anyway, because if you're in a subdivision, we got to review it. Certainly if anybody's going to demolish a property, to rebuild a building lot, to build, it's kind of more important than ever that we do a full 30-year search there to know and be able to advise the client that, you're going to fall into the scope of this C2 investments modification of the Marketable Title Act. Now, do you still need to be prepared that you might cause an uproar in the community? There's a difference between having the legal right to do it and whether or not people might still get upset, But that's where we just need to know, and you guys need to ask, and we need to know client expectations for what are they doing with this property. Because for some clients, this is going to bring an opportunity that never existed. And then for some of your clients, you're also going to I want protection against this type of risk or change in my community, right? There are different associations that I have actually heard from since this that are asking to be incorporated into the Planned Community Act. I think a lot of association attorneys are probably advising a lot of smaller subdivisions to go ahead and bring their developments into the condo, or not the Condo Act, but the Planned Community Act as a response to this. So I know that I've actually been asked to come and talk to some associations about what this is and why that would be worth it. It's a pretty big overhaul to a set of restrictions for a community. Takes a lot of participation. So they really want to understand it to be able to inform all the owners on why that would be protective to them. So that is the overview of the impact of the C2 investments as in the Marketable Title Act. So we can talk about questions on that if you guys have.
I have a question about the Planned Community Act. If a subdivision, for whatever reason, has become optional membership, is it still, does that have any impact on the ability to do that?
Is that, you're talking like Reams Creek maybe or somewhere?
Well, that could be one,
It's
but
one.
there's actually others.
Optional association, I know.
There's actually others I just ran into.
So I think an important component of that legislative change was you have to be under the Planned Community Act with an active association.
Yes.
That was created before the legislative change. So, you know, a lot of little communities might be subject to the Planned Community Act, and then they don't have, we've run into all the time, they don't have a formed association. They just pay a road maintenance fee to like some treasurer or something.
Yeah, exactly.
So an important component is they have to have an active association. Either a Planned Community Act requires a actual incorporated association under the Planned Community Act.
So paying a monthly stipend does not give you that ability to say that you have a active HOA?
No, because I think there, even if the membership is voluntary,
Yeah.
you could have an actual association there,
Yes.
you know? An association is a nonprofit corporation. It's formed with the Secretary of State. So you can form, you know, an association and have a board and then still have voluntary due collection. So it's not the action of the collection of the dues, it's formation of the actual association.
What if the association has been dwindled down to just one person, like you said, and they're just paying a fee to get snowplow or something?
It's still, as long as it's still an incorporated
Even if it's just
association.
one person, it's
Now,
still incorporated.
In a lot of smaller development or subdivision projects, they're an unincorporated association, and that is not a Planned Community Act association. Planned Community Act requires an unincorporated corporation. So it requires you register the association with the state, just like a company.
Do you have any thoughts on if you do run into one of these old subdivisions and it's now optional and it's kind of like some people will disclose that there is an association, people say there isn't, it's all that kind of thing. And not one person, I just did this, I searched all the way back every single listing from 2018 to now to see if anyone included covenants and restrictions with their listing. There are no documents and nobody can seem to locate them or say what they are. So how do we ever find it?
For the association?
Yeah, can the attorney, I mean, like supposedly nobody can find it and it doesn't exist because my buyer would like to review them, but.
Yeah, I mean, an association is a corporation. It's a nonprofit corporation, so it is supposed to have articles that are filed with the state to make the association.
They have the bylaws. that's all.
And then bylaws,
That's all
but
they have.
usually nothing beyond that, except maybe a budget
But they don't have the.
or
covenants and
board
restrictions.
appointment, you know, here and there. And bylaws are not a public record. Typically, they're just association records.
So that's all they have is bylaws. They don't have covenants and restrictions, and I'd love to find out if they can be located somewhere.
Search.
We'd have to do a title exam.
Because usually you find CCRs, but not any bylaws.
Yeah. I know, it's weird. All they have are bylaws. It's the weirdest thing.
Yeah, that is odd.
It is odd. The whole thing's odd.
The, I mean, I'd say in a title exam, we would search and confirm any restrictions we could find in 30 years.
Yeah.
There's a name of the association there?
Uh-huh.
I searched in the register of deeds under the name of that kind of subdivision name.
I'll do that.
Because they might just be old, and then people just stopped referencing them, which is how some of that stuff happens
Okay.
here. And then a title exam or any of the owner's title policies should list any restrictions in them as well. Any other questions about Marketable Title Act or?
If there's an HOA that was formed like in the 70s, as a planned community, but its provisions don't apply to the latest law, is this still a risk? But the Planned Community Act of 2022 and all the stuff they had in that.
Yeah, I'll just be clear, like a planned community, right? In terms of like lowercase planned community, like I planned 6 lots, I planned 10 lots and subdivide 10 lots is different than the Planned Community Act. Planned Community Act is, think of like the Limited Liability Company Act, the Corporation Act, the Condominium Act. The Planned Community Act is a statutory a provision in the chapters of our statutes that outline exactly what it takes to make a planned community. That you have to record the restrictions for it, and specifically it requires the association to be a incorporated association and provisions for the bylaws that are required. And that's the state's requirements to legally make one. So if you have a sort of deeded community that's never incorporated itself under the Planned Community Act, what we've done and what you see associations sometimes do is do amended and restated restrictions to then bring them under the Condo Act and then form the association. And problem here is you needed to do that before 2022 if you didn't have a formed association at that point. So at that point, if you're, my advice would be to that association or president would be, we were not going to do an amended and restated restrictions. I don't know how to view people's hands raised, so I'll figure that out in a second. Is probably a entirely set of new restrictions. Delete and terminate the old ones and just make a new one now pursuant to the Planned Community Act.
Okay.
And just make it new in 2025, and then we're way ahead of the 30 years.
Okay.
That's going to take all of the lot owners or unit owners to sign and notarize.
Every single one?
Yes, and arguably all of their mortgage lenders.
Oh, wow.
Or mortgage lenders too.
Yeah,
Yeah, makes sense. Easy,
Yeah.
easy.
Yeah.
yeah,
I know how everybody likes to sell that.
I know. But for a smaller community or something like that, you can still make a planned community under the act, even if you're under 20 lots. It's that if you're 20 or more, you have to comply with the Planned Community Act. But it doesn't mean if you're smaller, you can't comply with the act and make a community pursuant to the act. So if you have a smaller one, it's a little more realistic that you might be able to bring it in under the act in a new way. If you've never had a formal association. You see that a lot with bigger ones already did it. They've done it and have done it over the years. That's because they had attorneys
Yes.
representing the association.
If it was over 20 at the time that Planned Community Act was passed, did it require that they become part of it? Or did they automatically become?
I think
Or is it only effective going forward?
Oh, if you were a development that existed before the Planned Community Act, you were exempted. There's an
Okay.
exemption in that statute that you didn't have to comply with it. As long as you were created before, because I think it's 90, I didn't memorize the Planned Community Act, effective date 98 or 99, I think that went into play.
So then if you are over 20 and you were created prior to 1998, there's no aspect of the Planned Community Act that you need to comply with?
You don't have to legally comply with the Planned Community Act. No, before then, people were just making restrictions to make a common scheme of development, have some protections against mobile homes and, nuclear waste sites and all the things that you don't want on your property and your subdivision and do road maintenance. So it's just that the Planned Community Act was established because from the legislative opinion, you get so many lot owners, you need a structure to collect dues. Owners need rights as to when meetings are held and what notices are provided. And that's what the Planned Community Act provides, is that structure, so that the association and owners all have like equal protections and equal rights, and the organization in that bigger community. So that's the point of why the Planned Community Act was made. We had already had the Condominium Act to sort of give that consumer and owner protection. And so that was the response to try to apply to townhomes and single family communities to make a nice, good, fair structure for the association and owners' rights inside that. So, let's see if I can see what this is. Ask to unmute. Let's see. I need Matt or somebody. Hi.
Hello.
Hello. Do you have a question?
Yes, I do. My name is Michael. I'm with Springdale Realty, and I live in a neighborhood called Springdale Estates.
Mm-hmm.
That the original deed restrictions were formed in 1972, and
Right.
there are discussions in the neighborhood to try to bring it up to current standards based on all the material you've been presenting. And I have a question about private road maintenance. So those deed restrictions have establishes a private road maintenance committee so that they can collect funds in advance for the maintenance of the roads.
Mm-hmm.
And there's some that believe, and I'm one of those, that it could be that we can no longer collect funds in advance, that it will have to be paid for in arrears. Do you run into anything to do with private road maintenance in this subject matter?
Well, I mean, I do think it's very common for what I sort of call the casual Western Carolinian subdivision to just have dues for road maintenance. That's it. That's all we want, right?
Right.
All we need sometimes in a community. So I think it is, I think I would recommend is reading your restrictions as far as the right to pre-collect or post-collect the dues for that. It would be, I think, very specific in the way that it's worded in the restrictions about the requirement to pay. I think unless you have an association that is subject to the Planned Community Act, they aren't fiduciarily bound in the same way to do assessments and true ups and refunds, and unless that's specific in your restrictions.
It's not. It just says that they'll prepare an annual budget and send a bill, to the residents, but that they're collecting that in advance to pay for the maintenance in the coming year. And my understanding is that possibly if our current deed restriction is deemed to be invalid because of the Marketable Title Act, then those repairs would need to be made by someone, and then in arrears collect their receipts and say, here neighborhood, here's what I spent to fix the roads, here's your pro rata share.
I would think in terms of the requirement to make a budget, the budget would have to have a reconciliation if not all is spent in that next year.
Yeah.
Budget would show, right, the capital forward in the next year. Budget disclosures are, to be specific to what's collected and what's spent. Now, in terms of the Marketable Title Act and the C investments to the Auger, I could see a position of you or other owners saying, I don't need to pay those. We're subject only to residential use restrictions anymore. And I think that's a real example of a risk, not just the payment of the road maintenance dues, but any dues or any compliance with restrictions.
Okay, yeah, seems to be the only thing certain is uncertainty.
But what you could do there is really, if all that the community really wants is a road maintenance agreement, would be an updated road maintenance agreement that has a little more teeth in it for the structure. Everybody's got to sign it, but usually people, if everybody sort of has a commonality in agreeing it's not specific enough in how it's functioning, then you can always do an updated road maintenance agreement. That can allow for collection of fees and all the things, if that's all that y'all need.
Okay. Okay, thank you.
You're welcome. Thanks.
From a practical perspective, isn't that unrealistic?
Depends on the number of owners.
Yeah.
Chuns Cove Road, this was 15 years ago or so, had a property at the top of it, some road off of it, 32 owners, no road maintenance agreement. I cold mailed letters to right before Christmas, 32 owners. We got all of them to notarize and sign them back. Maybe the only time in my career that that's happened, but it has happened. And that's why it's stuck in my brain.
I hear that woman.
Yeah, I still remember like the names. They come in my office, I'm like, I know your name. Okay, so another one. This, I told you I'd get to one that I hear all the time, and this is the current event of short-term rentals. All the time, you see restrictions that say residential use only, which we know survives the Marketable Title Act. And or no business and no commercial use of the property or activities. So all the time I get asked, can we do short-term rentals of the property? There's this restriction. I just want the community to hear residential use is a use of the property. Short-term, long-term, residing in the property is residential use. Just because you're making money on it doesn't make it a business or commercial activity or change the type of use of the property. Restrictions are to use of the property. Now, if you're going to put a retail business in it, that's not residential use. But if people are renting it to live in it, that is residential use. Does that make sense? So that's just so there's 20 less emails that I send next month.
Is there ever a crossover, like a short-term rental is now being used for a wedding venue?
Much different.
Business versus a resident.
Yeah, much different, right? Because if they're just hosting the family for the wedding, that's residential use.
Yeah.
But they're getting paid out from outside source.
Yeah. I think people just think
But I don't know if that's the defining.
maybe distinctively that we're making money off of this,
It's the use.
and that makes it
not who's paying.
business or a different type of
But
use.
it becomes a business if you're getting paid, doesn't it?
Well, you're getting paid for the short-term use.
But they're
residing.
If someone's
They're
using
not
it
rent
for,
for weddings, and they're getting paid to use that property for a wedding venue, is that
If it's a venue to host an event,
right?
that is not residential use.
Right.
It is hosting the families for your farm across the
Yeah,
street. That is
your
your wedding venue.
Your family, yeah,
They can use that as all the short-term rentals.
if it's your family.
If they're living in it, if they're sleeping in it and using it as residential property. Residential property is like habitation,
I
right?
see, if they're living there.
Short-term,
they still get
long-term.
paid to have a wedding there, it doesn't matter. Because they're living there. The owner's living there, but they're getting paid to have a wedding at their house, that's fine.
Even if it were short-term rental and they have,
Short-term meaning less than a month or more than a month.
I'm just trying to figure out when use is different.
1 day, 1 month, 3 months, 7 hours.
Short-term can be anytime, but the homeowner is still making money on it, so then it's not considered a business.
Yeah, I just want you
I've
to
fought
hear-
Yes,
Yes.
with people on that,
Wait, what's the
and
answer?
they always say
So
that,
if they're
no,
paying and
it's,
sleeping there, it's fine.
they're
Right.
making money.
If
So
the owner's
it's fine.
living and sleeping there, but they're getting paid to allow people to have a wedding at their house, it's fine.
That's a business use.
Because
Okay.
people are coming there.
That's where you see in a lot of restrictions, they'll say residential use only, but you can still use it for home offices and
Yeah.
because they're trying to provide the exemption that you can still use it for work functions.
Right.
Because residential use is for residential occupancy.
Hmm.
Living, sleeping, protection of your space. So it doesn't matter if you're renting it out for that purpose, that is not a violation of restrictions on residential use.
So they have to have.
So if the
specific
owner
wording.
has an event venue across the street on another parcel that's not subject to the restrictions, but owns 5 lots in this development that are subject to residential use only, they could certainly do all of those as short-term rentals to support their business across the street. But that business can't be in those rentals, right?
Right.
Does that make sense? They can be part of the profit from that business across the street. So it's just something that I'm sure your buyers ask all the time when you go under contract. I still get questions from agents all the time. And so I just wanted us all to be able to have a discussion about that.
So it would need to say specifically, no short-term rental use or a specific day of, 30-day
No rentals less than 30 days. Yeah. And that's why you see that in modern, more recent developments, very specific rental limitation, timeline limitations, 1 year, 6 months, 3 months, 7 days. Yeah.
And or it was mentioned with some of the older neighborhoods that have the deed restrictions. For properties, this is kind of going a little off course, but with properties that are not part of the neighborhood, but broken off from like the family farm, they put deed restrictions on them. Do those expire in 30 years with the marketable title act as well?
Yep, that's exactly where this is gonna have an impact. Yeah. Yeah, you have lots of those. You have big pieces of land that were all deeded off, and maybe 3 or 4 of them all have the same deed restrictions in them, not to subdivide or only build 2 houses on them.
Minimum square footage.
So
Right.
I have a property for sale right now that has deed restrictions on it that was enacted in 92, so that's outside the 30-year period. Is there a process you have to go through to show that those restrictions are no longer valid, or they're just?
They're just no longer.
No, I mean, the process there is I'm gonna say, hey, whoa, let's slow down. I'm gonna do a 30-year deed history search of this property and make sure, yes, those are of that date, and then they've not been referenced anywhere
Okay,
in the
so
last
that's
30
the big
years
thing.
of title history. Because then it's just about advising the clients
If they
about,
were restated in the deed, it doesn't matter.
That's exactly what I was thinking about.
correct.
Okay.
They can be revived in the chain of title. Remember, Marketable Title Act says, if you have a chain of title that's clear for 30 years, then you're exempted from any interest not in that 30-year period of time, except what's in those exemptions. So if those restrictions are inside, then they are in that chain, they're in that 30-year period. So if they're in those deeds, then they're within and not outside of the Marketable Title Act.
So when we send you a new file, you need to be very specific that, hey, this is deed restrictions, but we believe they're, to kind of give you guys the red flag that we're gonna need that 30-year check. Right?
Yeah, maybe this is just a little point to talk about what attorneys do in title exams, because there's two types, and we always put this in our engagement letters to clients, but clients are over-informed and don't always read stuff. I get it. I don't always read stuff. And there's two types of title exams that we do for marketable title and insurable title under the contract. One is a 30-year full search, where we search the title back 30, 40, sometimes even longer periods of time just to get to a vesting deed. The other is what we call a title update exam. And that is if I have found a prior title policy of an owner in the chain of title that is a good policy, meaning it's sound and a good company, then that policy should be based on somebody else's opinion of the 30 years. So we use that and go forward often. And the benefit of that is the clients get a reissue rate. There's all kinds of good things there. So we tell clients that if we default to doing an update when we can, and if they want a full title exam, a 30-year, to reach out to us. I still get clients every once in a while that ask that specifically. So that's the ask. We want a 30-year title exam on this one.
Does the standard line C and D just says subject to all covenants, restrictions, easements, et cetera, restart that without, if it doesn't specify what they are?
They
Yeah.
have to be, they have to be
Yay.
stated.
Yeah.
You are blowing my mind. I just want you to know that.
She does.
It's the best lesson learned I've ever had.
Oh my God.
It's just because I run across so many deeds that are, that are no mobile homes, no manufactured homes, that kind of
Yeah.
stuff. Those deeds hadn't been updated since 1970 something.
All the time.
And all that is like dust in the wind.
Yeah, and what's been an interesting change of conversation, I gotta get to Michael Boss, that I've been having with clients is when I find them, no, I get asked to, how can we terminate our restrictions? I want to subdivide.
Yeah,
And then I'll look back and go, hey,
There you are.
we don't have to,
yeah, you don't have to do anything.
you know?
That's so stupid. Until the neighbor, sees that and then calls,
But the thing is, unless they can have a new argument,
right,
the courts won't hear it. Because the case has been argued. Once the Supreme Court hears it, you gotta come from a new angle and with a new claim, because you don't get to bring the same one twice. So it's gonna have to be a creative secondary lawsuit that tries to get back into this to provide more clarification. So you're subject to that risk,
right.
but, I don't know how practical that is. Yes?
Kind of a caveat for you. I live in a neighborhood that the POA was incorporated by the developer, 1997, 96, 97. 38 acres of undeveloped land. He developed it, still developing it. So in 2023, he flipped over the association to the homeowners. However, the homeowners refused to accept a quitclaim deed for the undeveloped property, and he's got 13 more lots to develop. They think he is subject to their restrictions. However, when I read the covenants, he cleverly had the attorney put in there that he was immune as a declarant from any sort of restriction to re-subdivide as he saw fit without any other approval.
Yeah.
So is he immune from those covenant restrictions? If he wanted
As to the
instead of
undeveloped
9
tract?
single-family homes, put up 2 condominium buildings, he could do that?
Yeah, always have to read the restrictions, give an opinion. I try to get away from the, it depends, like Gregory's been on, it depends, but it does. But another way to say that, read it specifically. It is not uncommon for a developer in a declaration to just say, I'm not subject to these. I'm not subject to the requirement to pay dues while I own any property. I'm not bound by any inability to subdivide or re-subdivide any property or create new easements for utilities, da, 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 da. So there might be enough in there that any property that remains in the developer is not subject to, or he can simply do a unilateral amendment to not be subject to those or re-subdivide or change those. So it's, and also I've asked whether or not that property was actually bound by those restrictions. A lot of developers will say, this is my first phase,
That becomes the
and I'm gonna add this one later with an amendment to the restrictions.
Well, that becomes a core question because each one of the individual owners that came in and bought a duplex or a quad has a warranty deed that draws from that 38-acre development.
Yeah.
Unfortunately, in the common area property that he still retains title to is a clubhouse and a pool.
Should have asked who the developer was in case of my
So the owners don't even own
client.
that. Now, they have the privilege of paying to upkeep it, because the dues are covering that. But the developer's like, I'm not paying you any dues. I'm not done developing. And if you're not gonna take a quitclaim deed from me for this property, and the reason they wouldn't is that he's all tangled up with the county and he owes them several $100,000 worth of remedial work on the storm drain.
Stormwater, yeah.
So, my curiosity is there a vulnerability for the owners for him to basically say, hey, in this context, am I immune from that until I finish developing it and we reach an agreement and I will transfer at that point? I don't know the answer to that.
So it's interesting. So typically a clubhouse or pool and those things would be on plat designated as common area.
I've looked. They don't exist on county records. They're all bundled into that 38 acres.
Was
And they're
it,
built in a floodplain.
is it it's a townhome development? Like a duplex townhome development, or is it a condo?
It is all quads and duplexes.
So townhomes and stuff, yeah. So like an interesting thing that brings up is, this is more development representation, but a developer, when they're done with a development, what we're talking about a quitclaim is that's called a turnover to the association. So they deed over to the association all the roads and common areas, and that's how developer sort of gets out of the development. So is the basis this developer's trying to be done with the development? Is that why?
He wanted to quitclaim it. It's the incoming board, the homeowners. They refused to take it over, thinking they had leverage over this whole county thing that he's back and forth on.
Yeah,
You know, that he hadn't
right.
remedied yet.
Associations often try to leverage.
Yeah, now I think it will eventually happen.
Getting the roads redone or something else.
Vulnerabilities are if he decides to change what he wants to put up on the hillside instead of
Mhm.
9 single families, does he want to put something else up there?
I mean,
Yeah.
A lot of that's.
We'd have to look at it.
restricted by the development code. I mean, you can only put so much, living space on, slopes and hillsides. So. Good God, Mom,
So-
what a mess.
Yeah.
What a can of worms.
So.
I would want to look at the title
Okay.
very clearly. I think the association or the owners should have an attorney do a very specific development title exam to know the developer's responsibilities and obligations as to their remaining property.
And I have one last question, then I'll leave it alone. In the transition eventually of that common property, is it advisable that they do a boundary survey to know what they're getting and what they're not getting?
I would certainly want to make sure I'm getting the pool and the clubhouse. But those aren't on survey and already surveyed out as
Because
parcels.
the neighboring properties, they're putting right-of-way easements in there for the new exchange off Liberty Road that they're
Mhm.
gonna put down into Canberra. So, I think everyone needs to know how close is that 160-foot easement gonna get to a property line?
Yeah, and I think the survey too then would just clarify that as common area. Because for two reasons. One, common then becomes everybody's use and it becomes a very low tax bill,
Ah,
like $100.
no way,
Common area is not taxed.
As opposed to a coordination or something.
Or just fee simple land, like usable development land. All right, Michael Boss, do you?
Yeah, thank you.
Okay,
Yeah, thanks. So another question related to Springdale Estates. So our original deed restrictions were created in 1972. They were amended in 2007. And sales since 2007, all the ones that I've seen, all the deeds that I've seen, including mine, because I live in Springdale Estates, was purchased after 2007. But the deed doesn't reference the amendment. It only references the original restriction from 1972. So what does that do to the 30-year chain? Is it property specific?
no, my opinion on that would be if I did a title exam, I would find the 2007 amendment, and that is within the 30-year period of time for the Marketable Title Act. So that would subject the property still to be bound by the restrictions, because an amendment restates the original set of restrictions it's amending. So then in that title, you are showing the claims for those restrictions in that same within that 30-year period. So my advice to any of those owners, and this is just mine, because of course I think there's going to be future lawsuits about the Auger case, is that you are likely very much bound by those restrictions.
Even if it isn't specifically noted in your deed, okay?
Well, yeah, because just for reference, if I do a title exam on you buying this lot, and I know you're in a subdivision by either the plat listing a subdivision name or association on the owners association disclosure, we run the development and the subdivision names when we do a title exam. Because I want to know if there's been an amendment. that you can't use property for something, or, you know, it's been subdivided, you can't subdivide. So we rerun associations and development subdivision names when we do a title exam. So we would run Spring Hill, for example, there and find that amendment.
So even.
So you comment, would you in that case
Runs with all names.
add that to the deed, to the exhibit A, the description of the property? Would you go ahead and update that for that?
I would, I think,
Okay,
just to be safe, I think it's worth it.
okay, great, thank you.
You're welcome. All right, does anybody else have any questions?
We're shell shocked.
Yeah.
Right.
I think we should.
Well, I'm surprised, I'm glad, because I thought this was, I didn't know if this was even like currently still a relevant thing.
Absolutely it is.
The 550 Lakeshore, you said that's gonna be, there's like a lawsuit at this point. I know they were having some heavy meetings, but what's?
I think it depends on how the meetings go.
Okay.
I live up there, and so does
Yeah,
Barrett
some
McFadder
or some
of Stone and
different-
Christie. And so he and I secretly talk about it. And then we volunteer who's gonna go to the meeting, wear a hat, stand in the back. Because everybody's gonna ask us questions if we do not, we don't wanna pull sides on stuff. So, you know, the meetings are all just keep happening, and I think it will depend on how it goes. He's already reduced the density from, I think, 30 some properties to 20 some properties.
Yeah.
What's this one?
That's
This
one
is
up
the
in
Lakeshore Park, or Lakeview Park, excuse me, off of Lakeshore Drive.
And I think if I remember correctly, Lakeshore, they have two different HOA, they're like depending on what portion.
Yeah.
It's kind of, like I said, there's one that's voluntary and then there's one that's not so voluntary. And it kind of,
But now it is.
now it is. Yeah.
All voluntary.
Now
You
it's
know, what's
voluntary.
interesting, Lakeview Park is kind of an interesting thing from a title standpoint. It's 500 different properties, all sometimes deed restricted and sometimes not. So we search back, and sometimes we find that they forgot to put the restrictions in the deed from the developer all over there. So there's tons of properties that were never restricted. Somewhere around 5 years ago or so, the association hired, Bob Deutsch represents the association a lot. He lived in Lakeview Park. Tikkun Gottschalk was part of his practice. They recorded an amendment to the restrictions and listed every property owner by name, didn't give them a sign, as all the properties that are subject to the association and the restrictions.
Yeah.
It doesn't bind, doesn't, I mean, like my name's in there.
It doesn't matter.
It doesn't bind me to them, but it was their attempt
Yeah.
to try to say, this is our planned community. Because they didn't do it. And by the time, you know, by the time sort of the Planned Community Act came out, there was just, I think, probably too many to do it. It wasn't, you know, modern era, right? Let's say I represent, I don't know, whoever developing 100 lots, I'm gonna do a declaration of restrictions and make that as a mothership master set of restrictions. You know, maybe in a mixed community, right? I might do a set of master restrictions and then a residential restriction for this part, a sub association for the business part. But that's not the way things were done even 20 years ago, let alone 30, 40, 50, 60 years ago. Lakeview Park was 40s, I think 50s.
They have interesting deeds when you
Yes.
read them.
Also, some of it unconstitutional.
Absolutely.
That's Beverly Hills.
Same with Beverly Hills, same with Biltmore Forest. Yeah,
Older.
Yeah.
Wow.
yeah.
So can I ask you a question just as a realtor?
Presuming that's the capacity we're in.
Your office, so you guys close a lot of my listings or wherever my buyers. And, your paralegal once said, hey, listen, go ahead and the legal description, also put in whatever it says in the tax or the property card, which usually is deed, the deed page, book, number. There's a restriction or plat with a plat. And I always thought, well, why? And now today I realize that I am just helping you, even though I'm putting the pen, I'm recopying what is on the Buncombe County or Madison or Henderson County property description, which is not the PIN number. Is that why? So you guys can look at it and say, oh, this is.
Yeah, it's because if you guys know, if you've been to closing with me, one of the very first things I do is I put maps on the table and say, look at what you're buying in a picture and tell me this is right. And that's because 5 different times I have done that. And what we're about to close on
It's not.
is not.
Oh, that you're
Yeah.
right.
And that's because the contract wasn't clear from the realtor. Now, contracts, as we know, have changed a lot. So you not just have PIN, you have address, you have deed books, plats, da, 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 da. Used to be so fast and furious, people would just write a PIN number, just write an address. So the point is, give me as much as you can so that I don't have to ask questions or have any ambiguity, because that's an all stop moment at the table.
Yeah.
So that's a different
Yeah,
different
I just want.
seminar to do. But those are planned, all of those were planned communities. No, one was a condominium. 2 were townhomes. One was actually a single family development. The builder had built 5 houses in a row. 1, 2, 3, 4, 5 lots, but listed on building 54321. So I got a street address. So 5 was 1, 4 was 2. So unless you look at street maps, I know lot numbers and unit numbers. You give me a street address, we'll find out whether we own that street address, you know? So anyway, thank you all for coming.
Thank you.
Yeah.